welcome to our Facebook Live audience. So happy you're joining me today. So what we're doing today is we are talking about the 10 power of attorney mistakes and how you can avoid them. So I'm so glad you joined me today. My name is Lynn St. Louis, and I am an estate planning and elder law attorney at ELG Estate Planning. So let's go ahead and get started. Oh, one more thing I want to mention, please put your questions in the chat if you're joining us on the webinar. If you're on Facebook, put them in the chat there, and Colleen will make sure that I see them. So we'll try to answer all your questions today. Also, stick with me till the end of the discussion today, and we will send to you a free gift. We'll talk about that further. Okay, let's go ahead and get started. So before we can talk about the mistakes of a power of attorney, I want to make sure you have a good understanding of what is a power of attorney. So when we say power of attorney, we're talking usually about a legal document, and that is a document that is provided for under statute. Every state has their own power of attorney statute. In Washington state, our power of attorney statute is based upon the Uniform Power of Attorney Act. And you can find that, if you wanted to look it up, at RCW 11.125. I'll get into that a little bit later in our talk, rather than getting bogged down in all the details. So it's a legal document, it's provided by statute, and what it does is it grants authority to somebody else to manage your affairs. So if you're the one who has filled out the document, the power of attorney document, you said, I trust somebody else and I empower them, I authorize them to act on my behalf, and typically it will be for financial matters and for healthcare matters. Now, it can all be in one power of attorney document. It doesn't have to be two separate ones for finances and for medical, though we find that it works better to have two separate power of attorney documents, one for finances and one for health or medical. So if you've probably heard about POAs or power of attorneys. Most people, when they say POA, they're actually referring not to the legal document, the power of attorney document, but they're referring to the person that they've appointed under it, and it's just called a POA. You're my POA. Technically, that person is your attorney in fact or your agent, and they are the person authorized under your power of attorney to act on your behalf, either because you just want extra help or because you can't act. Some incapacity has occurred so that you are not able to manage your own affairs. So this is one really important thing that I want to get out during defining what a power of attorney is, and before we get started about the mistakes. Your power of attorney must be durable. It must say in that document that it is a durable power of attorney. The reason for that is that the whole idea with a power of attorney, really the main reason anyone would ever have it, is to make sure that if anything happens to you so that you can't manage your own affairs, somebody else can. Well, if your power of attorney doesn't say that it's durable, then your power of attorney document is ineffective at the point that you lose capacity, which is the time that you absolutely need to have that document in place. So when we're talking about powers of attorney and mistakes, etc., we are talking about a durable power of attorney document. Critically important, just as by definition, that your power of attorney document be durable. One other thing I want to say, we do estate planning. We help clients protect assets. We help clients qualify for government benefits, long-term care, avoid taxes, et cetera, et cetera. In my opinion, as an estate planning attorney, and I've been in practice for many, many years, your durable power of attorney is the most important legal document you can have. Why? because it's the document that protects you while you are alive. All the other documents are important, you know, your wills, the things that will come into effect after your passing. But when you're alive, the durable power of attorney is the document that makes sure your voice will be heard no matter what happens to you. So that's why I say it is the most important legal document. And, you know, most people don't realize that because everybody knows about a will, but powers of attorney, they're looked at as kind of collateral or, you know, documents that aren't so important. They are really important. Okay, so let's get started. What are the 10 most common power of attorney mistakes? Number one, failing to have this legal document. That's the biggest mistake anyone can ever make, is not having a durable power of attorney legal document. So why would somebody not have it? Well, because they don't realize how important it is, or perhaps they just thought, oh, all I need is a will. One of the reasons people might not realize the importance of it is they don't understand the consequences of not having it. We'll get into that. But it's also because they don't understand, well, if I don't have it, what will happen to me? And really what it gets down to is people never like to think that they could ever become incapable of handling their own affairs. It's kind of, you know, a paradox with estate planning documents. You do all this work to make sure that whatever happens, you're protected. And then you pray that nothing ever happens to you and you'll never use those documents, at least not until you pass away. So part of the reason people don't do estate planning in general, and in particular power of attorney documents, is they think, I'm never going to lose the ability to manage my own affairs. I'm a perfectly capable person. That is really normal. That's very common. If that's, you know, kind of where you're coming from, totally understand it. But my job as an estate planning lawyer is to help educate people about the things that I see and about the risks that they will encounter potentially in their life if they don't have these fundamental estate planning documents. So number one biggest mistake is not having a durable power of attorney document. So what are the consequences if you don't have a power of attorney document? Well, if you're healthy to the end of your life, you probably won't feel any consequences of it because, you know, you manage your affairs until the day you die. But what if, like most people, statistically, probability-wise, you need long-term care or you end up in the hospital, even if it's just an acute incident like a heart attack, or you're under anesthesia for a surgery? There's a lot of reasons that you are unable to speak for yourself, either to your doctor or to handle your financial affairs. And if it's a short-term situation, you're not going to see a lot of consequences from that. The hospitals always have their own form that if you're going into surgery, they'll have you sign something. It won't last forever, but it's just to get through that one situation. But what if you were to lose the ability to manage things for a long time, either a stroke, for example, a traumatic brain injury, or, you know, cognitive decline, dementia, Alzheimer's. So if you are incapacitated for a long period of time, what's going to happen is that the court is going to take over your business for you. It's called a guardianship. It always has been. It's also called a conservatorship. Let me just give you a little brief explanation about what that means. It truly means that your business, your affairs, your financial, your personal, your healthcare, all your affairs are taken care of by the court. The court will appoint someone to be your voice. Why do they do that? Because you didn't have a durable power of attorney. And somebody has to manage your affairs. You're alive, you're incapacitated, but somebody has to manage your affairs. It's going to be the court. And the court is going to declare you to be incapacitated, is going to require financial statements filed with the court, audits, personal needs, reports, It's costly. There's going to be somebody appointed as your guardian. It may be somebody you know. It may be a certified professional guardians. They do a great job, mind you, but it's not the position you want to be in if you could at all avoid it. How do you avoid the court getting involved in your personal business? Have a durable power of attorney. That's number one. It's critical. It's the most important thing I can tell you. That's all you take away from today's talk. Good. Durable power of attorney. Make sure you have one. Second biggest mistake with powers of attorney is appointing the wrong person. Remember, I just talked about how important it is to have a power of attorney to avoid the state's involvement, so that somebody could be your voice. Really, this is the key piece. Not just avoiding the state having you under a guardianship if you ever lose capacity, but somebody is to speak for you. You want that to be the person who really will reflect your wishes, your thinking, your voice. You need to appoint someone you trust completely. You trust them with your money and your life, actually. You trust that person. So you might think, well, I need to appoint my eldest child, son or daughter, whatever, because, that's what I should do. No, think deeper. Who is it that you would appoint who has a good head on their shoulders, can take care of business, can get things done that needs to get things done, who can keep track of any financial matters that they're handling for you, who can keep good records? Who is it that you can rely on to get the business aspects of your life taken care of? Now, this is what I'm talking about now is more for the financial part of a durable power of attorney. That person, that right person, not the wrong person. Who's the wrong person? The wrong person is one who doesn't understand what they're doing, avoids paying bills, puts their head in the sand, can't get things done. Their life is always in turmoil. We all know and have people we can think of. They're the wrong person. Don't appoint them, because the work won't get done. And the whole idea of this is so that, your life can be continued on and be managed even when you're not capable of doing so. I mean, you might be serving right now as a financial power of attorney for your spouse or maybe for your parent. And if you are, think about what you're doing. You're paying their bills, you're keeping the checkbook. Checkbook is, are you paying things electronically? That's fine. There's still a digital record of what you're doing, and you're doing it for them, not for yourself. It's a job that you're doing for them, and hopefully you're doing it in a really business-like manner. You might be making sure that their taxes are getting filed, working with their accountant, or filing them yourself. So the financial power of attorney, appointing the right person, is appointing somebody that can get the job done, and they do it well. I mentioned that appointing somebody under a power of attorney is so that your voice will be heard. When it comes to finances, it's making sure that the business aspects of your life are being handled. Your voice being heard is more so when it comes to your personal decisions. Like if somebody needs to talk to your doctor about, well, what treatment is appropriate, and you can't do it because you are not capable of communicating with the doctor, with the physician at that time. Well, who is? You want that person to be somebody who knows you very well, who knows what your wishes are, who knows how you want to be treated in terms of how much medical treatment do you want? Do you want everything possible under the sun, no matter what the outcome is? Or do you say, no, I just want to get this medical treatment, and if I'm not going to get any better, then please stop the medical treatment. You want somebody who is going to be your voice. And importantly, that person has to say your voice, what you want, not what they want. So let's say you are the power of attorney for your parent. and you had to make a decision about, well, do you withdraw life-sustaining treatment or not? That's a hard decision to make. You might know that that's exactly what your mom, your dad wants, but it's really hard because you as a child don't want to give up and see your parent pass away. It's a hard decision. And my point, what I'm saying is when you're thinking about who you appoint to be your power of attorney for healthcare, think about somebody that has it in them to say, no, withdraw this medical treatment. It might be the hardest thing to say, but it is the right thing to say. So make sure that whomever you appoint isn't wishy-washy or says, I don't know what to do, that they go, you know what, I know that this is what mom wants and I am going to be her voice. It's hard, but I am going to do it. So when you are thinking about who to appoint as your power of attorney, reflect on your life circumstances, the situations you've been in, and that will help guide you as to, okay, who can be my voice for me, for finances and for healthcare, and appoint that person. I do want to mention that sometimes, people don't have anybody in their family or any friends that they feel confident could carry out that job, those responsibilities. There are professionals that we have can refer to. There are people that are either banks or trusts, institutions for financial powers of attorney. There are others who serve as healthcare agents, people that may be care managers. So there are always options available to you. So if you say, I don't have anybody available, don't let that stop you, because as an estate planning firm, we are able to help guide you to say, hey, here's some suggestions about professionals who will do a very good job for you when the time comes. Okay. Number 3, not understanding that giving somebody this responsibility, being your attorney, in fact, the person you're appointing, is a job. It has responsibilities. And this kind of ties into what I was just talking about. So I won't spend a ton of time talking about it, but sometimes people say, well, I have to appoint them because they're the oldest or this or that. This is not an honor. This is a job. This is a responsibility. If you've ever served as somebody's attorney, in fact, and if you've had to go to the doctor's appointments, schedule appointments, attend, if you've had to manage finances, that this is not just okay, sure, I'll do it. No, this is a job. This is a responsibility. So as the person who is filling out the power of attorney, hopefully with the help of your estate planning lawyer, you yourself are understanding that there's a lot that goes with this. Maybe not initially, because when I fill out a power of attorney now, like for example, for myself, I've appointed my husband, and then if he can't serve, then I've appointed my kids. They're not serving right now and doing anything active under my power of attorney. And that's usually what it looks like. Nobody is doing anything right now necessarily. But you have to acknowledge that if they ever do have to serve, there's a lot of responsibility that goes with that. And that is something that I think is really important for everybody to understand, that this really is a job that people need to take on when that time comes, to help you by acting under your power of attorney document. Oh, and when somebody serves under a power of attorney document, they actually have legal responsibilities under the statutes. They are considered a fiduciary, and a fiduciary means that they have a high duty of responsibility, of loyalty to you, to do what you would do, not to do what they would want to do. So there are legal obligations that come with serving as a power of attorney. So, you really should talk with the person to make sure that they're up to accepting those responsibilities. They might say, sure, it's okay. And then when they think about it, they go, I just can't fit that into my life right now. I've got too much going on. So do talk with the person to make sure that they're not only the right person, but they are willing and up to taking on the responsibilities of the job. Sometimes, this is number 4, fourth mistake, having 2 or more people serve jointly as your power of attorney. Sometimes clients will say, well, I can't decide, so I want both of my kids to serve as my power of attorney. It's like, okay, let's talk about that further. Why might that be a good idea or a bad idea? Usually we try to counsel our clients not to have people serve jointly as their power of attorney. The reason for that is sometimes the 2 people won't agree. Let me give you an example that was, one of the, I mentioned that having a power of attorney is to avoid a court-ordered guardianship. Well, I've seen a situation where the attorney made 2 people joint as the power of attorney, and that actually led to a guardianship, the opposite of what you would hope for. Well, why is that? Well, here was the situation. The attorney drafted a power of attorney for the husband. And in the power of attorney, the husband said, well, I want my new wife to be my power of attorney. And I also want my son from my prior marriage to be my power of attorney. And I want them to serve jointly. If they serve jointly, when people serve jointly, usually it means that they have to agree on everything that's done, all the financial decisions, how to spend the money, where the care facility will be, what kind of medical treatment, on and on. You can just imagine the scenario. Well, no surprise, stepmom and the son could agree on nothing. As a result, there was a court-ordered guardianship that had to be put into place because they would not agree. Nothing you could do could get them to agree. So the whole idea of having a power of attorney is so you don't get into a guardianship. If you appoint the wrong people as joint and they have to agree on everything, that's kind of a recipe for disaster. And it was in this situation, and there was a court-ordered guardianship. That's just one of the reasons not to appoint 2 people and say that they have to serve jointly, and agree on all their decisions. From time to time, we do say, okay, you want your child and your new spouse to serve jointly, and there's some good reasons for that. Let's have it so that they can each serve, but their decisions can be independent of one another. They talk all the time, they get along fine, there's no weird dynamics, but maybe somebody is better about writing the checks and somebody is better about doing this, and they're always talking with each other. So you can appoint people to be joint but independent, meaning they can each transact business. That is kind of an exception to the rule. It's pretty unusual. We do it from time to time, but only in the unique situation where it will work. That's what you're always thinking about. Will this work or will this cause more problems? So I'm not going to say that you can never appoint people jointly as long as you say that they're independent in their decision making, but independent ironically means that they're going to talk with each other and share all the information. So that can be done. Usually though, it's not done, because usually having 2 people to serve as your attorney in fact, as your agent under your power of attorney, usually is a bad idea. Number 5, failing to name a backup agent, a backup attorney in fact under your power of attorney. So oftentimes we see people just go, okay, well, I'm going to appoint you as, my agent under my power of attorney. Phew, I'm done. No, you're not. Why is that? Well, I'm sure you can follow this line of thinking in estate planning. We are always asking, and if you worked with us or another estate planning attorney, we're saying, okay, well, what if this happens? All right. Well, what if that happens? Usually people go, I never thought about that. And frankly, it's not your job to think about all these things that could happen, all these contingencies. That's what an estate planning lawyer does, is we ask, what if this, what if that, what if this, what if that? So if you're just appointing one person first in line to be your attorney in fact, and nobody else is named, what happens if that one person you've named can't or won't serve? Well, you don't have a good durable power of attorney then. You have nothing in effect. And if you're incapacitated at that time, you're under a court-ordered guardianship. So don't just name one person. Name the first person, name a second person, and then we ask you to dig really deep, name a third person. So why do you do that? If the first person can't serve, then the second person can. If the second can't, then the third person. Do we go to the fourth level? Not usually, but you always can. The likelihood is, though, that if you name one, then two, then three, you are never going to have a problem with having somebody who is able to serve under your power of attorney document as your agent. So you want to name successive layers of people, 1, 2, 3, as your attorney in fact. One other thing is if you say, well, I can only name 2 people, my daughter and her husband, we are really going to push you further on that one. I usually say, do your daughter and her husband drive together, travel together, do things together? Well, of course they do. Well, then there is a higher risk that something will happen to both of them at the same time. So let's name a third person. So if you're ever naming a married couple, even if it's in a successive order, you've got to name somebody else to go in that list of people who might serve for you as well. Number 6, biggest mistake, failing to make your durable power of attorney document effective immediately. You have 2 choices when you're filling out a durable power of attorney document. Do you make it effective right now, right when you sign it, even though you don't expect anybody to have to serve under it for a long time? Or do you say, no, my durable power of attorney document is going to be effective upon my incapacity? It will spring into effect later when a doctor says, I am not capable. Sometimes people who are less comfortable with the idea of granting authority to anybody over their financial or healthcare affairs says, I don't want it to be effective right now. I mean, I only want this person to step in if they need to. So I want my document to be effective in the future when my doctor certifies that I have lost the ability to manage my own affairs. Seems logical, doesn't it? At ELG Estate Planning, we do a lot of work with long-term care. We do a lot of work with seniors whose cognitive abilities might be declining. A lot of work where people have Alzheimer's. If any of you are familiar with dementia, have a family member, or just have any familiarity with dementia at all, you'll see this. People have good days and bad days. On their good days, you would not know that they have any cognitive issues at all. On their bad days, you know. Dementia is typically a gradual progression. The disease process gets worse and worse and worse. But there is a period of time, it's kind of this gray zone, when it might not be so evident to a doctor. Let's say it's for your mom, for example. And you know your mom, you know that she's losing her ability to manage things. But when you go with her to the doctor, she is sharp as can be, and funny too. So the doctor says, I'm not gonna sign any incapacity statement. And you're going, you really need to, because this is what mom did yesterday, and I'm fearful this is what she's gonna do tomorrow, and this and that. So we find, and other healthcare professionals or others involved with long-term care will, say the same thing, I believe, is that the springing or the effective upon disability power of attorney is problematic. I don't recommend it, period. I recommend the immediately effective. And then you say, well, Lynn, I don't want the immediately effective one because I don't want anybody to act on my behalf. I'm perfectly capable right now. It's like, yeah, I hear you. Nobody wants that. Do you trust the person that you've appointed? Yes, I trust them. Have you talked with them? Yes, I've talked with them. Do you know that they'll carry out your wishes? Well, of course, that's why I'm appointing them. So what's the problem with making it immediately effective? You're going to take your power of attorney document, you're going to give it to them, and you're going to say, here, I want you to know that you have this in case I'm in an accident, something happens to me, I'm at the hospital. You have a copy of my document, but I am in great shape now. I can handle all my affairs. Of course, you are not going to step in and take over and manage any of my affairs. That's why I recommend the immediately effective. It forces the conversation up front to give more information, to make sure that you've appointed somebody you trust who's not going to step in right now and try to take over your affairs. So make your power of attorney document immediately effective. Seventh biggest power of attorney mistake is not putting in that document specific authorities. This really doesn't have so much to do with the medical. The medical one is pretty simple. It's usually in the form documents you'll find online. It's usually like one paragraph. You can make decisions for me based on my healthcare directive and withdraw treatment, etc. When we're talking about not including the specific authority needed, we're really focusing on your financial power of attorney. So your power of attorney document can grant about as much authority as you have. Really, what you can't grant is authority to change your will. That's always reserved to you. But power of attorney documents typically will say you can manage my real estate, my banks, my investments, filing my taxes, dealing with any kind of personal property I have, buying and selling a car, handling insurance, annuities, litigation. Just think of all the myriad things in your life that have to do with, business aspects of life. So power of attorney documents typically, as a general grant of authority, say they can do all those things. Where people run into troubles is with not granting very specific authorities. You see, under the Uniform Durable Power of Attorney Act as adopted in Washington, we have a statute that says if you want your agent to do certain things, you have to spell that out in your document. And if you don't do that, they will not have authority. They won't have authority, for example, to do a transfer on death deed. We often want clients to be able to do that on behalf of the principal. That's who signed the power of attorney document. That's the principal. Let's say they've lost capacity and they wanted to avoid probate, but they didn't do that. They didn't set up their estate plan correctly to do that. Well, we could avoid it by a transfer on death deed. But in order for your agent to have that authority, you needed to say that in your power of attorney document. The Washington statute changed on January 1st, 2017. So if your document is older than that, you likely need to go have your attorney look at it for you. And frankly, as a rule, 5 years, look at all your estate planning documents. Banks often want to see them even fresher than that, but let me not go astray right now. Let me talk about specific authority. Make sure you include specific authorities. How are you going to know what to include? I mean, you can just look at a form document and they might have boxes and you'll check the boxes. What did those boxes mean? What did you do by checking those boxes? It's really important that your attorney explain to you, well, what does it mean, for example, that they can do a testamentary transfer? Well, a non-testamentary probate asset transfer on death deed. Why might you want somebody to create or revoke a trust? Talk about that. Why might you want somebody to have the authority to make a gift, and make a gift not just to the $15,000 exclusion amount, but beyond that? Why might you want somebody to make a gift of all of your assets, for example? I mean, that seems really extreme, and it is really extreme. We here at ELG Estate Planning do Medicaid asset preservation strategies. Sometimes as a part of that, part of our strategy so that the person won't lose all their assets to the nursing home is to gift them all. And to gift them all And if they don't have capacity, I need authority under a power of attorney, not just to gift them, but also to protect them. So there are times when gifting away assets makes a lot of sense. What we do here at ELG Estate Planning, because gifting is such a risky authority to include beyond the $15,000 annual exclusion amount, is that we say, if you're doing gifting for Medicaid qualification purposes, we require that an attorney, not just the attorney in fact under your power of attorney, but an elder law attorney, put in writing, this gift is because of this plan and benefits and does what the principal wanted it to do. You want an attorney to back up the gifting so that there is not gifting that is done that is a bad idea. Medicaid has a 5-year look back rule. So if we're doing any gifting within the 5 years, you want to make darn sure that whoever's doing the gifting of your assets knows what they're doing. They're not going to know what they're doing unless they're dealing with an elder law attorney. And that elder law attorney better put in writing what's going on so that they can stand behind that plan. Other specific authority to change beneficiary designations or rights of survivorship on bank accounts. This is a really important one that we do, to change property status. Let's say you're married, and let's say that you're married and your spouse needs to qualify for Medicaid, but you don't have a power of attorney or you have a power of attorney that doesn't grant you authority. If one spouse is going on Medicaid, we are going to transfer all the assets to the healthy spouse, the community spouse. Well, how do we do that? How can we make sure that there is nothing standing in the way of doing that? We want authority under the power of attorney that says we can do that. They can revoke a community property agreement. They can do a separate property agreement. If you want your spouse to do that, you have to specifically state that in your power of attorney. And the majority of powers of attorney I've reviewed that are done by traditional estate planning lawyers that don't do Medicaid don't include that provision, because they're not thinking about, well, why would you want to do that? There's really good reasons to do it, as I just explained, but many power of attorney documents and forms won't have that. And it's really important that you have that if there is ever a concern that your spouse might go on Medicaid. There's other specific grants of authority. Those are under RCW 11-125-240. If you're interested in taking a look at that, calling if you do it. RCW 11.125.240. You can read the statutes and you can do your Google research and you can do all that. But what I want to caution you about is, no matter how good of a researcher you are, unless you're an elder law attorney, the implications, the consequences of certain specific grants of authority and how they're used and why they're important aren't going to stand out to you. So be cautious about that. And just like what I'm telling you today, probably should have said this up front. I'll try to remember to say it at the end. What I'm giving you isn't your specific legal advice. It is information. If you want specific legal advice about your situation, talk to an attorney. Retain an attorney who knows estate planning, and not just estate planning, but elder law and government benefits, special needs types of benefits. Okay. One of the reasons I think that's important is, everybody can find a form online and fill that out, and you can do that. But what you're going to not get from that is, what does it mean? And how can it be used? And how can I plan for the future? If you just have a form, you have a form. That might be adequate to keep you out of a guardianship, but that won't be adequate to give you that roadmap forward so that you know what your future legal and financial situation might be in case of all these various scenarios that might happen. That's what an attorney does for you. Number 8, making your agent a joint owner of your bank account. There's a lot of reasons for this confusion. People think that if I just put somebody on my bank account, I don't even need a power of attorney. And there's reasons why you might think that. I mean, it makes sense. If you make somebody a joint owner on your bank account, they own it with you. They have all the rights that you have. And by doing that, they can transact business. They can withdraw money, they can put money in, they can do all sorts of things. So it's kind of like, in lieu of having a power of attorney, people say, well, I just will make this person who will transact business for me, my child or whomever, a joint owner on my bank account. The reason that's a really, really bad idea, especially if we're talking about any sum of money beyond just enough money to pay for funeral expenses, is that it's their money too. You've made them a joint owner. You've made them a gift of this money. If they have a divorcing spouse, if they cause a car accident and they don't have enough liability insurance, if something happens where somebody sues them, they have creditors, they come after them, that bank account that was yours and is your money now is going to be susceptible to those creditors' claims. And you'll have to defend against that to say, oh no, it was my money. I didn't intend to gift money. It's really not their money. The whole idea with doing good estate planning documents is avoiding having to argue and fight in court about what should be. Your durable power of attorney says what should be. If you make somebody a joint owner on your bank account, you've thrown confusion into everything. So I don't recommend that you do that. Another reason not to do that is upon your death, the joint owner, let's say you had 3 kids and the joint owner, you said, well, you had 1 kid as a joint owner, I said, please divide it with, your siblings when I'm gone. They go, of course I will, Mom. What happens when you're gone? Well, that joint owner might have been the one who took care of you, who helped you with everything and did all this stuff with you. And they say, you know what? My siblings didn't do anything. They really don't deserve anything. So I'm going to keep it. And then litigation will result. And then it'll be for the court to determine who really should get that money. So don't make that mistake. Don't make your agent under a power of attorney a joint owner of your bank account. One of the things that be careful of is when you go to the bank, they might say, oh, just do it this way. Just make them a joint owner. And be careful where you get your legal advice. Don't get your legal advice from the bank. Don't give your legal advice from your accountant, your financial advisor, at least when it comes to what your estate planning document should look like. See an attorney, because everybody is willing to give you free legal advice, except for the attorney. We charge for our legal advice. So be careful where you're getting your legal advice. Another reason people might think that they don't need the power of attorney is because, let's say that they're married, and that means your spouse is a joint owner on your bank account with you, and you don't have a power of attorney. And so why would you need one? I mean, you're married, Washington and Idaho, they're community property estates. Why do we need a power of attorney? Well, what I like to say to clients is, have you ever thought about the time you try to call on your spouse's credit card and they say, oh, I can't talk to you, put your husband on the line or whatever? You need a power of attorney even if you're married, and a lot of people don't realize this. You have joint ownership of your house and on your bank account, so you don't think you need a power of attorney. But think about this, when you sold your house or bought your house, your spouse needed to sign just like you did. If your spouse can't sign for any reason, how are you going to sell your house? How are you going to buy your house? You can't. There'll need to be a guardianship if that person, your spouse, has lost capacity, and you need to transact any type of business like that. So people are surprised to learn just because you're married doesn't mean you can transact business for your spouse. You can't unless you're a joint owner, like on a bank account, but that does not work for real estate. Mistake number 9, not contacting your bank or financial institution and providing to them your durable power of attorney. Your durable power of attorney, especially if it had an attorney do it for you, is a good enforceable legal document, period. So people are often surprised when later their agent or their agent goes to the bank and the agent is told, well, you can't transact business. We've never seen this document before. Banks, financial institutions all have their own policies, and those policies might not align with state law. In fact, they frequently don't. So they'll have their own rules to say, well, we won't accept that document. We've never seen it before. I tell my clients, take this document you just signed, take it to the bank with your agent and say, bank, I want you to have my power of attorney document on file. I want you to meet my agent. And then they have it on record. And sometimes what they'll do is say, oh, that's a really good legal document. Hey, let's have you sign our own because we like our own form. Go ahead. What you've done is you've pushed the conversation forward so that you know in the future, your agent will never have any troubles, either because they signed the bank's own form, which wasn't necessary, by the way, but the bank thinks it is, or the bank didn't require their own form and they have your power of attorney document on file. Your agent's not going to have trouble. Clients sometimes will go, well, this is just wrong. You are right. It is wrong. The bank should accept it. The financial institution should accept it. There is actually a statute that allows me as your attorney to go file a petition with the court and force the bank to accept the power of attorney and force the bank to pay my legal fees. Great. That's a solution, but it's not the solution we want. Remember, with estate planning, the solution is to try to get things set up so everything is easy, not more difficult. So these power of attorney mistakes is kind of the practical how-tos of what I suggest that you do to make things easier for your agent whenever they have to act under a power of attorney. 10th mistake, assuming your power of attorney document extends beyond your death. It does not. When you die, so does the authority under your durable power of attorney. Very frustrating, perhaps not for you, but for your agent. They often come and they say, well, I'm the POA. I should be able to do whatever I want now that mom has died and do everything that she said I should do and carry out her wishes. And it's because of a misunderstanding. A power of attorney, as I mentioned, is a lifetime document. It is not a post-death document. The authority under a power of attorney ends when the person has died, when the principal has died. What that means is, well, what's the next step? Well, this is where people really get frustrated. What is the next step? It depends on how the estate plan was set up or was not set up. If the estate plan wasn't set up because it was formed powers of attorney, the next step is going to be a probate. And then the person who's going to do the probate is going to try to do it on their own, or they're going to see an attorney. There's going to be legal fees. If the power of attorney was set up through an estate planning process with an attorney, then that person who was your agent will know, okay, well, mom's estate plan was set up to avoid a probate. We did a transfer on death deed. We did beneficiary designations. We did all these things because we knew that probate avoidance was the goal. Or there will be a probate because we need to protect assets for somebody. So we needed the probate process to protect assets, to defeat creditors' claims for all sorts of myriad reasons. But they'll know that the next step would be to see the attorney. And yes, there's a probate because that was part of the plan. So what's important for you to understand is that a power of attorney document authority ends when the person dies. One exception, and it's a pretty important exception, under the healthcare power of attorney, the healthcare agent does have continued authority after the death to make decisions about the remains, to decide that there's going to be a cremation or a burial or whatever there may be. So that's kind of out of necessity that our statute says, oh, you're the healthcare agent, then you are the person authorized to say, what do we do with your loved one's remains? Okay, that's 10. Before I move on, I have to add an 11th mistake. Sorry if I'm dragging on, but this one I think is really important. It's fraud. How do you avoid fraud? People are worried about powers of attorney and granting authority because they don't want the person to steal from them. Well, everything we've talked about right now up to this point is choosing the right person, talking about responsibilities, et cetera, having a lawyer involved. That is going to help mitigate any kind of risk of fraud. Where do you see fraud in powers of attorney? Where you see fraud in powers of attorney is online documents. Where you see fraud is, pick on the son, The son prints something off online, takes it to mom who's losing capacity or has lost capacity, and says, Mom, you just sign here. Mom signs, it's notarized, it's valid, or there's two witnesses who are independent. It's valid, assuming that, well, it looks to be valid. Whether or not it's valid, that's a whole different question. But where you see fraud, where you see problems, where Adult Protective Services comes in more often than not is when there is a family member who just presents to their older family member, their parent, here's a document, please sign it. It'll make things so much easier for you, Mom. I'll just help you out with everything. That's where you see fraud. So be careful with online documents for all sorts of reasons. And I can tell you that when an attorney drafts a durable power of attorney for a client, we, in our experience, have not ever seen fraud by the agent. I can't say that it's never happened, but I am completely unaware of any sort of fraudulent instances. Having the attorney involved kind of keeps people away from committing fraud against the principal who signed the power of attorney if there's a lawyer involved. All right, that was number 11, bonus, avoid fraud. So for those of you who stuck with me, I said that there'd be a free gift at the end. If you're joining us Zoom, we are going to send you a certificate for a free consultation. I hope that today I've raised a lot of questions that you need to have answered. If so, please take advantage of our complimentary consultation. Typically it's $375. If you qualify, we'll send you the certificate. We'll follow up with you. If you qualify, you'll get an opportunity to speak with us directly. For those who are on Facebook, please send an email to webinar@elgwa.com, and we will go ahead and send you that same certificate. Let me see what type of questions I've got in the chat before we wrap it up today. First question is, so if joint agents who can act independently are appointed, I've been told that banks and title companies still often require both agents to sign. Is that your understanding? Absolutely. I think I try to point out that having joint is bad for a number of reasons. One of the reasons I didn't mention, so thank you for the question, is that financial institutions and banks, they won't play along with having joint. They won't agree to joint, either have to make decisions at the same time, so they both have to sign, or joint independent. They'll require, they simply won't allow it. They'll say pick one or the other. So for a lot of reasons, banks and their policies, and this is probably a pretty good policy, they won't allow you to have a joint signators on your account for joint attorneys, in fact. For those who had to leave early, this is recorded, and for those who send us your email, we'll send you a link so that you can watch this again. Another question is, should I provide my financial advisor 401k with power of attorney documents? Yes, you should. And especially when you're talking about 401k, they will often have their own power of attorney form. And so it's better to get it dealt with while you have capacity, while you can. When you're thinking about, I'm setting up my estate plan, I want to have this right for my family, talk to your 401k advisor, say, where do I send my durable power of attorney? And they might say, oh, just send it here, great. Or they might say, oh, we have our own form. Just like I mentioned with the bank, it's fine for you to complete their form. Just make sure you name the same people so that there's no confusion. And so where do we send to get the free certificate? That's webinar, WEBINAR, @ELGWA.com. And we'll put that in the chat for you. For one of our Facebook listeners, how many original powers of attorney do you need? Typically, there's going to be one original power of attorney for finances and one for health. You are going to make copies, and you're going to give those copies to the banks and to your primary physician for your healthcare one. Oftentimes, though, they'll say, well, let me see the original. So you might want to bring your original, and bring the copy, or just bring your original in and make the bank make their own copy. We at ELG Estate Planning have a practice where we actually have our clients sign 2 original general durable powers of attorney. Those are the financial powers of attorney. The reason for that is it's not that unusual for people to not be able to find them, to lose their original. And if we have to record anything with the county, it is far easier if we're recording like a deed or a property agreement, and it's through the authority and the power of attorney. We want to record the original document if we are taking those sorts of steps. So we at ELG Estate Planning actually have our clients sign 2 original financial powers of attorney, and we keep one. That is not necessarily every lawyer's practice. It's something that we have found that our clients benefit from. So that's what we do here. If you're a current ELG client, yes, you'll get a certificate, but one of the benefits of being a client that's already done estate planning with us is just contact us and you will, we typically offer complimentary reviews. It's a part of our client care program for our clients. Come back in, meet with us. If it's just reviewing your estate planning documents, we're happy to review them. Usually with our current clients, if they say, okay, now I have a question about Medicaid or I have a question about probate, since we've already done your estate planning documents, we typically will simply meet with our clients, our existing clients, and then give them guidance. But we'll send you a certificate anyway. It's always good to have. All right, it is just about 1 o'clock. I thank you all for staying with us to the end here. Any questions, reach out to us at ELG Estate Planning. That's 509-468-0551. We're in Spokane, we're in Tri-Cities, we're in Seattle. We're happy to help out, answer any questions that you have. And again, thank you so much for being with us today. Take care.